What if I was 1% at fault in an auto accident? Can I recover compensation? That's our topic on this episode of Main Street Law. My guest is North Carolina personal injury attorney Michael A. DeMeo of the law offices of Michael A. DeMeo. So Michael, thanks for being here today.
Pleasure to be with you, Cindy.
Well, Michael, what is the answer to that question? Suppose I was rear-ended by another driver and I'm injured, but I wasn't wearing a seatbelt. What happens to my claim?
In North Carolina, Cindy, that really doesn't matter. In North Carolina, we're one of 3 states that have what's called contributory negligence. So if you're even 1% at fault, you don't recover anything. One of the few exceptions is they cannot introduce evidence that you weren't wearing your seatbelt. So that will not be a bar to recovery. But any other form of negligence generally would be.
Now what is the difference between contributory and comparative negligence?
Generally, most states in the United States have a version of comparative negligence, which essentially says if you're less than 50% at fault, you recover less your percentage. For example, if you were deemed to be 20% at fault and the defendant 80%, you would get full recovery less 20%. So you get an 80% recovery. There are 3 states, North Carolina being one of them, where if you're even 1% at fault, you don't recover. So the example would be North Carolina, South Carolina. In North Carolina, you're going down the road, someone pulls out in front of you, they allege you're speeding, you're more than 1% at fault for that because you were speeding, you would recover nothing. In South Carolina, let's say they attribute 20% to you at fault because you were speeding, you would still recover less than 20%. So it's a huge distinction. North Carolina has some very strict rules and regulations about how you can recover if you're involved in an accident, and it's very important that you not give any information out before you seek legal help.
Okay. Now you said North Carolina is one of the only 3 states that has this law.
That's correct. North Carolina is one of North Carolina, I believe it's Virginia, Alabama, and there's one other state. I believe it may be the District of Columbia, but there's generally only a few states in the entire nation that still have this law because it's fairly antiquated and it's pretty unfair because even if you're 1% at fault, you recover nothing. And people sometimes don't get that. And unfortunately, when they don't get that and they don't do the proper things at the onset of their case, sometimes that causes their case to be denied or devalued significantly.
Well, Michael, do you see any hope of North Carolina changing to comparative negligence?
Ironically, there was some provisions actually this year in an effort to make the change, but the other side, the insurance industry, put in so much other negative provisions into the bill that it really wasn't worth giving up joint and several liability, paid versus billed. It wasn't really worth giving up to get comparative. So it did not pass.
Okay. Michael, what are some of the cautions in dealing with the insurance company?
Well, generally the insurance company, their job is to get rid of you quick, cheap, and quiet. That's how they get paid. That's how they make money. The attorney's job is diametrically opposed. Obviously, the better we do for a client, since we work on contingency, the better we do financially. So we have a vested interest. We have a built-in interest to do well for the client, whereas the insurance company has the opposite. From a practical standpoint, some of the tricks that the insurance companies will use is right after the accident, they'll give you what they call a short sale or a quick settlement offer. They'll get you to sign sometimes a medical authorization, which is a big mistake. And sometimes they'll do a recorded statement, which is not required, although oftentimes they'll tell you that it is. Their job is to investigate the claim so that they can either deny it, delay paying it, or defend it if you go to court. So the reality is when people say the insurance company is being very nice, sure they're being very nice. They don't want you to get an attorney because statistics show that when you get an attorney, you generally recover 3.5 times more with an attorney than without. So what that says is even someone like myself charging a third, the client's net recovery is always going to be better as a general rule with me as opposed to without me. And every once in a while we'll get a case where, we say, you know what, we're really not going to add value. we'll tell the client that. We'll be very honest and say, listen, your case is small. You only went to the doctor a few times. There's only X amount of value for your pain and suffering. We're not going to benefit you as much such that us taking our fee, you're going to come out the same, so we're not going to take your case. But think about us in the future if you should need us.
Excellent. Great information. Well, Michael, if someone has specific questions, how can they reach you?
They can certainly contact us by our toll-free number, which you can reach us anywhere in the United States, which is toll-free 877-333-1000. We answer our phones 24/7, 365 days a year. Or obviously, if they want to do a little research on our firm, they can go to www.dimeolaw.com, and they have a myriad number of abilities to get in touch with our office or ask questions or do research so that they can feel comfortable about our experience, knowledge, and our dedication to them.
Very good. Well, Michael, thank you so much for your time today.
My pleasure.
This is Cindy Speaker for State Law TV.